Okay, yeah.
We're live.
All right.
We're live. Namaskar, everyone. Like very warm welcome for this first SCAORA lecture series of 2025. It is a distinct privilege to have this lecture here today, which we are which we really promise to be an enlightening session. We are truly honored to host a very distinguished legal personality and a name that resembles with excellence and a profound legal insight. Senior advocate and former Additional Solicitor General of India, Shri Atmaram N.S. Natkarni. We eagerly anticipate the wisdom he will share with us today on the topic of an overview of the PMLA, its history, objective, and the relevant provisions. Before we delve into the heart of the session, I would like to invite Dr. Meenakshi Kalra, a member executive of SCAORA, to formally introduce our esteemed speaker today.
Good evening, everybody. It's my distinct honor to introduce to you an eminent legal luminary, Natkarni sir. With a distinguished career spanning several decades, Mr. Natkarni had made significant contributions to the Indian legal system. Born on 23rd November 1963, Mr. Natkarni completed his law degree in 1986 and went on to earn his master's in law from Mumbai in 1991. Mr. Natkarni's professional journey is marked by several prestigious appointments. He served as an Advocate General for the state of Goa twice, first from 1999 to 2005, and then from 2012 to 2016. In 2016, he was also appointed as the Additional Solicitor General of India, representing the nation before the Honorable Supreme Court of India until June 2020. Throughout his career, Mr. Natkarni has been involved in numerous landmark cases. In recognition of his outstanding contribution in the field of law, Mr. Natkarni was honored with the Abhimanshri Award by the Murgaon Education Society in 2023. Beyond his professional achievements, Mr. Natkarni is known for his commitment to mentoring young legal minds, having guided numerous juniors during his tenure as Advocate General. Mr. Natkarni also writes a regular spiritual column in the Viva Goa magazine monthly. Today, we have privilege to have Mr. Natkarni sir share his insights on the Prevention of Money Laundering Act, PMLA, a topic of paramount importance in our legal landscape. Please join me in welcoming Senior Advocate Atmaram N.S. Natkarni sir. Over to you, sir.
Thank you, President SCAORA, Mr. Vipin Nair, Executive Committee members, and my dear friends. At the outset, I would like to express my gratitude to the President and his Executive Committee for having given me this opportunity to be in the midst of this young intellectual minds. Thank you so much. A few things before we turn to the history of the Prevention of Money Laundering Act. The concept of money laundering is a very interesting topic. Basically, the whole money laundering legislations all over the world started on account of a great don in the United States who actually, through all sorts of activities, amassed huge wealth, which we call, number two wealth, which was illegally gained wealth. And he was a don, Al Capone. Now, this don was to such an extent that he was fully stuffed with wealth, but none of this was white in nature. So he could not use this particular wealth, and he found it extremely difficult. Therefore, he came out with an idea by which he started utilizing that wealth, so he used to invest it somewhere in the form of cash and get returns in the white. In other words, the concept of laundering of money is because whatever is sent to the laundry, we send our clothes for dry cleaning or for washing, etc. When they come back, they are very clean, crispy and creased, right? So that is the concept of money laundering, that whatever money he used to invest, they used to come back fully laundered, cleaned to him. And that is how the proceeds of the crime which he accumulated, ultimately he increased his net worth by laundering this particular money and his wealth. That is how this concept of money laundering came. Indeed, in countries like United Kingdom, United States of America, and for that matter, even Switzerland and many other countries, these legislations have been there for last several decades. In India, it came only after the Financial Action Task Force came into picture, and they said all the civilized nations of the world must have a control over this money laundering which is going on, because this goes on across nations, across continents, and all over the globe. In India, most of us know we have a parallel economy. The Dandekar and Raj survey of 1951, immediately after independence, said that India has a parallel economy. All economists in the world also agree that India has a parallel economy, in the sense the black money, the cash economy plays a vital role. That's why whenever there are recessions also, India, if you go to the mall, they are still blooming and in great prosperous way they are doing their business. That said and done, it was in the year 2002 that the Atal Bihari Vajpayee government, as it then was, brought this particular legislation. In 2002, though this legislation was brought, it was brought into force somewhere in the year 2005. And thereafter, several amendments came to be made. The first amendment was in the year 2005 itself, where they operationalized the structure of this particular law by bringing in enforcement directorate, what you call the ED today. 2009, there were several other amendments also where they broadened the scope and definition of money laundering itself. And the whole PMLA was given new features, including the Financial Action Task Force recommendations. 2012, there have been amendments significantly widened the scope by adding certain scheduled offenses, because the Act has to have scheduled offense. Only then, if the predicate offense is there, will the money laundering get attracted. 2019, certain other amendments were done whereby they clarified the ED's powers, then reversed the burden principle, and several such amendments. The whole objective of this Prevention of Money Laundering Act is that money laundering by itself is a criminal offense and imposes stringent penalties on those who engage in it. Now, for example, in India, we had the Prevention of Corruption Act. All my friends here today who have logged in, I'm sure will not deny that there is mass, large-scale corruption in all sectors of our country. That is because more controls which we have in our country, these more controls breed more corruption. Now, we had the Prevention of Corruption Act, we had certain provisions in the IPC, we had the Coffee Posa Act, Conservation of Foreign Exchange, Prevention of Smuggling Activities Act. Then there were so many other NDPS, etc. All these particular acts and the criminal activities therein generated lot of money. And this lot of money was not through a white source, not through a tax-paid source, but the money used to get accumulated. And this money was eventually laundered, in the sense it was sent elsewhere, and the proceeds of this crime were diverted systematically for people to gain and make them white in the process. Now the government of India, the parliament later realized and came out with this Prevention of Money Laundering Act. That is insofar as the history of this particular act is concerned. Now, objectives also we have seen. Objective is to avoid the proceeds of crime which are generated from being laundered or from being used, and therefore to detect them and put it back into government coffers, or to send it back to the victims of the crime who have lost this particular money. The salient features of this particular act is the first one being the proceeds of crime, the second one being the attachment of the property or the value of that particular property. Because sometimes you might just have parted with the property, you might get a value, and you might purchase something else out of that property. So even the value of the property is taken to be a proceed of the crime. The third important thing is the facilitation of the effective investigation and prosecution. So these are the three broad objectives. Now, having seen that broad objective, there are certain key definitions which are required to be seen under this particular act. The first one is Section 3. What is money laundering and how is it defined? A person who directly or indirectly gets into or generates or involved in a proceeds of crime, including the concealment, the possession, the acquisition, the use, or projecting or claiming such proceeds, which are an untainted property, is the definition gets attracted. Now, this proceeds of crime refers to any property derived or obtained directly or indirectly by any person as a result of a criminal activity relating to a scheduled offense. So if you generate some money where the scheduled offense is not attracted, then of course PMLA is not attracted. But by now, after the amendments, they have brought in wide range of offenses, whereby many of the offenses under the Indian Penal Code, many of the things like environmental violations, illegal mining, all this have been brought inside. The scheduled offenses, of course, all of us know, these are the predicate offenses or the underlying offenses, and these range from severe offenses under Indian Penal Code, the Narcotic Drugs and Psychotropic Substances Act, Prevention of Corruption Act, the Environment Protection Act, many other such, this one, wherever the scheduled offenses generate some illicit gain, the proceed of crime gets attracted. Now, the importance is the predicate offense must be there. And unless the predicate offense is there, a prosecution cannot lie under the PMLA. One of the celebrated judgments is Madan Lal Chaudhary's case. In Madan Lal Chaudhary's case, while upholding certain provisions of the Act, the Supreme Court categorically said that predicate offense must be there. In the absence of a predicate offense, a prosecution or an ECIR under the PMLA is not maintainable. Now, when we go to the detailed provisions of the PMLA, it has provisions like, as we said, the proceeds of crime, the enforcement directorate, which is the operationalizing institution which looks after this prosecution. Then there is a provision to file an ECIR. Then there is an adjudicating authority under Section 6. Then there is a provision for attachment first and for confiscation under Sections 8 and Section 9. Then there are powers of search, there are powers of seizure, and there are powers of even arrest under Section 16 to 19 of the Prevention of the PMLA Act. Then the records and reporting is also very important, which is under Sections 12 to 15. Various banks, financial institutions, even intermediaries, are required to identify their client base, the client records, the record of the transaction, and furnish supporting documents in case a transaction is found to be suspicious by the Financial Intelligence Unit or the Air Intelligence Unit of this Directorate of Revenue Intelligence. Then there is a provision for special codes, which are under sections 43 and 44. So the special courts are designated and set up by the central government. They conduct trials and deal with the offenses under the PMLA. The trial of a predicate offense and the money laundering offense can also proceed together, thereby guaranteeing an integrated approach. Many a times what can happen is the procedure of crime may be there, but the actual offense under the Prevention of Corruption Act of receiving bribe is not proved. In which case, the property will have to be returned back. It is possible. For example, under the NDPS Act, if a person is caught with the drugs and ultimately, if in the course of the trial, he through defense evidence proves that the money which is found with me, found with that person, accused person, is in fact the genuine money, then that money will have to be returned back to that person. But of course, if that is not proved, then there is now the principle of the reverse burden, which is done by sections 23 and 24, because in interconnected transactions, the presumption of all these related transactions is that the approach has been tainted unless proven otherwise. So therefore, the burden is on the party who is found with the proceeds of the crime to prove that this money actually is a genuine money. And this is what is called in our jurisprudence as the reverse burden principle. It shows that the prosecution has to only show prima facie that this is a case where money has been found. This is a case where money was sought to be laundered. These are the proceeds of crime. And the onus with that shift onto the accused person to prove A, that the property is not tainted, and B, that the source of the property is genuine and it is accountable. These are, various facets of that particular law. Then we have certain sections dealing with international cooperation, around 56, 61. These are sections dealing with that, international cooperation, etc. By and large, this is a very important part of law, because till today, the government of India has been able to return around 30 to 40,000 crores to various financial institutions. So this is a very welcome step where people who had invested money in the bank and the banks were going down the drain have been, their position, financial position and status has improved after the government has got hold of this money, and this monies have been returned back to these financial institutions. There are a few judicial pronouncements which are required to be looked into when we go into the working of this particular act. This was a new legislation. Suddenly the ED was found to be raiding some people. Something was found. And of course, it is possible that while administering this act, the enforcement directorate officials might have crossed their limits, might have misbehaved, or might have done certain wrong things for blackmailing, etc. It is possible, because after all, the human beings are dealing with these things. And no part of the human being, there can be a guarantee that the approach will be completely, 100% guaranteed to be within the four corners of law. But just because there is some misbehavior on the part of the ED, or just because there have been one or two examples or a few examples of misuse of this act, we cannot countenance the position that the illegally gotten wealth must be brought out and must be equally distributed back to the victims, or it must go into the government coffers. because ultimately it will be the public exchequer which will benefit and which money can be used for infrastructure or other purposes, etc. Over the last few years, there have been allegations and counter-allegations that this act has been politically misused. It's possible. Nobody can deny it. I'm not aware of it. I cannot speak. I'm not the proper person to speak on it, whether it has been misused politically or not. But in a given case, if a politician is a corrupt politician and has indulged during his tenure as minister or officer, whatever it is, in some ill-gotten activity and done illegal things and generated certain amounts, why should such politician or bureaucrat not be proceeded against under the Prevention of Money Laundering Act? This is just a thought process, because certain important things which are to be seen in this, and it is at this time when the hit was being generated somewhere in the year 2017, because 2014, after the present government, that is Modi 1.0, came into power, that this act came to be used in its proper sense. The act was implemented. Prior to that, it was not implemented. Now, the first case which went to the Supreme Court out of the Punjab High Court was the Nilesh Tarachand Shah. A case came from Gujarat, case came from Bombay, case came from Madras, and case came from Punjab High Court, where the Punjab High Court was the first one to strike down the provisions of Section 45(1), that is the twin bail conditions. Because granting of a bail, for example, you have POTA, then you have so many other laws, including NDPS, where stringent bail conditions are there. So such stringent bail conditions, twin conditions, where and are there under Section 45(1) of the PMLA Act. Matter finally rested in Supreme Court, and the Supreme Court, by a judgment, which is, it's a reported judgment, 2017, 11 SCC, page 1, held that these bail conditions which have been imposed under Section 45(1) violate the personal liberty guaranteed under Article 21 of the Constitution of India, and therefore struck down this. Now, significantly, this led to a legislative amendment whereby the Parliament reintroduced these twin bail conditions, slightly modifying words here and there, and to make it constitutionally valid, and pass that. These constitutionally validated amendments of PMLA came to be challenged in the celebrated judgment of Vijay Madanlal Chaudhary versus Union of India. That's a judgment reported in 2022, 10 SCC, page 201. Now, Vijay Madanlal Chaudhary gave a very comprehensive ruling. The judgment was a 3-judges bench headed by Justice Khanwilkar, and it gave a ruling on various aspects of the PMLA, including the first and important thing is that the Enforcement Directorate officers are not police officers. Therefore, statements recorded under Section 50 are admissible in evidence. The reverse burden principle was also constitutionally upheld, saying that Section 24, given the socio-economic and seriousness of the money laundering activities, that this principle of reverse burden needs to be had. The third thing is the arrest provision. The arrest, search and seizure provision, they upheld, and that is why this judgment came to be criticized by many, and it has now been referred to a larger bench also, again for review of Madanlal Chaudhary's pending before Supreme Court, where the Madanlal Chaudhary judgment said, this provision we uphold, but they read it down saying there has to be a reason to believe backed by tangible material. Now, if there is a reason to believe backed by tangible material is concerned, the bail can be denied. Of course, there will be two schools of thoughts. One which always says that the salutary constitutional principle enshrined in Article 21 of the Constitution of India, which guarantees right to life and liberty of the citizen, is so sacrosanct that no statutory provision can take away that. The other school of thought would be that if a person is really guilty of the offense, then, and if prima facie material is found with them, why should a bail be given? Personally speaking, I am for advocating the strict enforcement of the PMLA. But before you arrest or go for search and seizure, not only should you have the reason to believe, not only should you have the material evidence, but you will have to find out whether a detention of the person is essential. See, because when you detain a person, you definitely restrict his right under Article 21 of the Constitution of India. And as compared to and in contrast with any other statutes, right to life and personal liberty under Article 21 is the greatest of the fundamental rights, which is envisaged in Part 3 of our Constitution. There is no gainsaying about it. I do not think this principle can be countenanced. But at the same time, for example, you have a POTA Act, you have a Gangsters Act, you have certain activities like anti-national activities, waging war against the state, or some such activities where TADA, POTA, etc., where they can be done, because that is where you indulge in activities against the nation. And those activities are required to be prevented by the person who has indulged in such activities. That is why it is in the larger interest of the nation that you detain a person, because a private detention of one person is far better if that person is a threat to the whole society at large. That principle cannot be straightaway imported into Section 45(1) of the Prevention of Money Laundering Act. A, because this act deals not for punishing, it deals with the proceeds of the crime and the punishment thereof, prosecution and punishment thereof. The crime is committed under another act. For example, if a money is generated through illegal drug trafficking or indulging in an act of corruption, then that basic predicate crime is under the Prevention of Corruption Act or under the NDPS Act. The money which is generated, that is sought to be detected, captured, and brought back to the rigors of law under the PMLA. Now, just a general proposition which comes to my mind, assuming a person has indulged in money laundering, what benefit will you get by detaining him physically through his body? If your whole approach of this act and the objective of the act is money laundering and prevention of money laundering, on the physical body of the person, money is not there for sure. So what will you gain by detaining that person? The money is elsewhere, and by the time you detain him here, that money would have rolled into so many hands. So the basic concept is, we have our intelligence agencies, we have the various other detective agencies, etc. These agencies together in a concerted effort must study and do a little research and on how such persons who can be, where this money laundering takes place, can be detected, can be tapped, and can be, brought to the books of law. Instead of personal detention of a person, all right, if you want to do some investigation, take a day, take 2 days, but this detention for 3 years and 4 years, and it really messes up one's life. Now, I'll give you a classic case which I had done in the Supreme Court, and the Supreme Court granted bail. The accused persons had taken loan from the Union Bank, and they were a well-established company in South India. They took about, total loan amount was some 800 crores, out of which, without any default, they paid up to about 360, 370 crores. When it came to the next installment, COVID started. And from 2020 to 2022, there was a default. This company was doing work of timber. They used to produce timber through their agricultural property, and the sister concern used to have a sawmill where the timber products, finished products would be made and sold. As a result of COVID, there was no sale, there was no proper plantation done because there was no funds given to that company. Whole thing went into a mess, and all of us know that COVID actually upset everyone's life, not just in India, all over the globe. For some reason, and I'm sure it is not the economic reason, but it was some other reason, extraneous reason, both the brothers were prosecuted and were jailed. Not only were the brothers jailed, their wives were directors. Their children were also directors. All of them were made accused persons. Fortunately, others were not arrested. The two brothers were arrested. As a result of which, the whole business went into a slump. The general manager of that bank said that these companies were genuine company and they have never defaulted. Here in the past, they have taken loan. We have no complaints. The bank officials were not prosecuted, but these two brothers in that company were prosecuted. And it is so unfortunate that when the matter came up before Supreme Court, the Madras High Court denied bail to them. Special Court denied, Madras High Court denied, matter came before Supreme Court. I remember it came before a bench presided by Justice Sanjay Kishan Kaul. And I explained the whole thing to him. And he said, what is this? Because the additional Solicitor General said they have diverted the funds. So I explained the diversion. I said, diversion is the sawmill company, that is the timber company, gives advance money to the sister concern, which is an agricultural company. And I said, they buy seeds, etc. Thereafter do the plantation, and that plantation is purchased by me, and thereafter the money is transferred. I said, this is from one company to the other, which is also a sister company. And these are all accounted transactions. Mind you, these were not some diversification that I took money from X purpose and bought it for Y purpose. The Supreme Court recorded in the order, because the law officer was again and again asking for time. Supreme Court recorded in the order that this is prima facie a matter where we want to grant bail, and ask the solicitor to produce material or file affidavit if they want to seriously oppose it. After 2 days, they came, the same story, that there is diversion, these, that and all, nothing material, nothing. So I said the two brothers were never involved in any offense whatsoever, not even a traffic offense. And now they have been loitering in the jail for almost 1.5 years each. The Supreme Court immediately granted bail, only observing that this was a case which should have been actually, bail should have been given by the High Court. I am only giving this as a matter of illustration that it is Supreme Court which thereafter opened the eyes of the High Court for granting bail to the accused persons. Otherwise, it was a matter of course that the special courts would not grant bail, the High Court would not grant bail, and finally the Supreme Court, depending on which court it comes before, you would secure a bail. Now, where an offense is made out, where the case is such that there has been a frequent and a consistent act of money laundering, where the amount involved is so high that to release a person becomes a flight risk, or some such thing, then one can understand that, the bail conditions are to be strictly imposed and enforced against such accused person. But in a normal case, once the investigation is over, you can't keep a person under detention perennially till the trial is over. There are some 100-odd witnesses, thousands of documents. Now you'll wait for everything to be over and then thereafter grant bail to that, thereafter release him. And at the end of the day, if there is acquittal, what will you do? How will you compensate that person? So most unfortunate, the attitude and approach of the high courts, that like special courts, they also started rejecting bail. I do not know whether it was out of fear of the letter of law or whether out of fear of something else that they were not granting bail. The high courts and the Supreme Court are constitutional courts under 226 and 32. They have got the repository power of issuing writs. These courts are on the sentinel qui of the Constitution. Personal liberty is something which they must enforce as a part of their duty and not simply enforce the letter of law, because 45(1) says that we can't release. So we'll now look at the 45(1) and stay contended. This part of the administration of the Act, forget about ED misbehaving and all, this is basically a judicial failure on the part of the constitutional courts. For the information of SCAORA Executive Committee, I have said this in so many words at the SCAORA conference in Goa also, where there were Supreme Court judges sitting and High Court judges on the panel with me. I've said it openly, I'm saying it now also. But at the same time, I also add a rider to that I'm not saying that the Money Laundering Act should not be enforced. It should be enforced in the strictest of the terms. Wherever the proceeds of crime is there, that thing should be attached, confiscated, seized, confiscated, and brought back to the victims or to the government or the banks, whatever it is. But at the same time, detaining a person unnecessarily and this judicial approach of not enforcing Article 21 and not enforcing this bail jurisdiction is something which went a bit off track, which should not have gone. Thankfully and gratefully, Supreme Court has now realized the position and it has started granting bails. One important facet, there are two judgments. One is Satinder Until of Justice Sundaresh, and there is one more, I can't recollect the name offhand, this delivered by Justice Abayo while sitting in court number 6 or 7. Both the judgments have taken the matter much further. This, for example, in Satinder Until's case, the person was not arrested by the enforcement directive. They found that there was no need to arrest such person. And when the matter was charge sheeted in the court detained him. Now, if the investigating officers decide not to arrest you, when the question of at the stage when the matter is in the court, you are
No, see why? Because otherwise,
so the thing is, why should the court, and at the stage when the matter is charge sheeted, why should you be arrested when you are not arrested? Satinder Until is on that point. Number 3, reason to believe that judgment of Justice Abayo is also a great judgment. Several judgments are there. We have Gautam Kundu's case, we have Rohit Tandon, then Shekhar Reddy's case, Padmanabhan Kishore's case. All this revisited the question whether merely because there is an ECIR, is it akin to FIR?
just to accentuate things, ऐसे एक wall को सजा दिया आपने, लेकिन overall ये ही जाएगा wall bracket donors.
Very sorry, just a second.
this is more show them for, Like your thing.
Now, there are certain other principles which also are required to be gone into. For example, the requirement of reason to believe. Then there is this reverse burden and the constitutionality of this reverse burden principle. Then the admissibility of statements. Then the predicate offense versus the money laundering offense. So these are all challenges as regards the implementation of the Act. These are matters of complex financial investigations, and it is possible that the agency jurisdiction may also overlap while administering these acts. But at the same time, these money laundering aspects have the global dimension of crime. Each of these money laundering offenses can raise various variants of a vexed question. So therefore, it is not that the Money Laundering Act should simply be, implemented with rigors, without rigors, etc. But while implementing the Act, the principle of reasonability, the principle of fairness, the principle of transparency should all be put on it. Why should there be certain sunlight is the best disinfectant? If ED has material, they should take it out and show it. Show the mirror to the accused person and then show it to the court that this is what it is. I do not understand why, what is the secrecy about these documents? If the accused himself does not know what documents you have against me, how will the trial go on thereafter? No, only at the trial we will produce. We will not give investigating papers. See, those are all antiquated views of investigating papers and investigating officers who used to have those loose papers, etc. So most of us know how these investigations take place. It is not wrong to say that many of these investigations are at times tainted also. And these officials go overboard. But that apart, that is not the subject matter of today's thing. But as I mentioned, that these are various things, the global dimensions, the stringent bail conditions, the overlapping agency jurisdictions, the implementation challenges, the complex financial investigation aspect. And for the purpose of true implementation of this Act, we require an international, global, legal cooperation. All of you know how many of the accused persons are sitting in London, how many are sitting in UK, how many are sitting in Dubai, how many are sitting in other parts of the Romania and all those places. Several accused. Many of them have not been extradited as yet. Many people have taken the money, the proceeds of the crime and invested in British Virgin Islands. Many people have taken it through what is called the Hawala route, through India to Dubai, etc. So, if you want to really enforce this particular Act, you have to have a reasonable, transparent, well-organized, balanced enforcement. And at the same time, our judiciary must have oversight, and the evolving jurisprudence must be noted by judges, the special court judges, high court judges, and the Supreme Court judges, and they should administer the Act and be an actual watchdog over the activities of the Enforcement Directorate. Because after all, what happens is, if the fence starts hitting the crops, who will protect? The whole system will collapse. That should not be the case. And the future outlook is a balanced enforcement of this Act and a strict judicial oversight where the judges make the Enforcement Directorate accountable. And once the Enforcement Directorate puts before you that this is the material, then you proceed against the accused person. If he is not able to justify his source of money, if he is not able to account it, then go all out against that accused. So, ladies and gentlemen, my time was 45 minutes. I have already reached the 45th minute. So therefore, I would not be able to, I can, but I can't, because of the paucity of time, enhance this any further. I mean, going into more details, etc. So these were my views. So if there are any question answers, then please.
Kaustubh sir, are you there?
Yeah. Thank you so much, sir, for sharing. Thank you so much, sir, for sharing your valuable expertise with us. And your lecture has undoubtedly has enriched our understanding as far as the PML is concerned, and it's all overview and the basics and the depth also, sir. I would like to invite our president, Mr. Vipin Nair, to share a few thoughts about the lecture, sir.
Thank you, Natkani sir, for a wide-ranging and absolutely incisive lecture. It was a treat. And the advantage you had was that you brought in your experience as a law officer, senior most law officers, and also now as a crusader of protecting personal liberties in your private avatar. And as you said, the PMLA has panned out to be a case of the watchdog becoming the bloodhound. And that is what you said, the fences eating the crops. The whole purpose is defeated because the person inside is incarcerated for so long that it's a vendetta kind of a regime now. And according to many proponents of this peculiar jurisdiction, they said this is the most draconian piece of legislation ever. And you have very simply, by bringing in the earlier Al Capone days and the recent Raid Raj, really educated all of us. It was an absolute pleasure, sir, to have you. Thank you so much.
Thank you. Thank you.
Sir, please unmute Kaustubh sir.
Thank you so much, Vipin sir, for your very insightful reflection about the whole aspect. Now I request our member executive, Ms. Pragya Parijat Singh, to actually deliver the vote of thanks.
Thank you, Kaustubh sir. Honorable Atmaram N.S. Nadkarni sir, Senior Advocate, Supreme Court of India. On behalf of entire Supreme Court Advocate on Record Association Executive Committee, I consider it to be my proud privilege to express my gratitude to you, sir, for taking this compelling and riveting section on PMLA Act, its history, objectives, and key provisions, in which you have exhaustively covered the entire gamut of the Act, along with subsequent amendments and up-to-date provisions. Thank you yet again for delivering a phenomenal lecture on this important piece of legislation, thereby starting 2025 lectures on a high note, sir. The saved videos are very much accessible on the official YouTube channel of Supreme Court Advocate on Record Association channel. And the fellow members who have missed the glorious lecture can also access the same on the YouTube channel. Thank you on behalf of all of us, and very sorry for the intermittent disturbance. I think Amit sir was on the ground, and because of some issue, it got unmuted. So very sorry, sir, for that. But otherwise, the lecture was phenomenal. And we look forward to having you yet again, not just in Goa, but also for another lecture on some important piece of topic. Thank you, sir.
Thank you so much, Pragya. And I'm really grateful to everyone for attending this lecture series. And I really hope to see you all with this very high energy again in our next SCAORA lecture. And it will be very soon. Okay, sir.
Thank you
So much.
I'm very sorry, sir. Extremely sorry. It got unmuted. I'm very sorry, sir. I owe you apologies, sir.
Thank you. No problem. No problem.
Thank you.
Thank you. Thank you.